If you're Turkish and you have been researching how to move to the Netherlands as an entrepreneur, there is a very good chance you have been studying the wrong process. The startup visa, the self-employed permit, the 95-point RVO scoring system. You may have spent weeks or months understanding how these work. Hollanda'ya girişimci olarak taşınmayı araştırıyorsanız büyük ihtimalle yanlış süreci inceliyorsunuz. Startup vizesi, serbest çalışma izni, RVO puanlama sistemi, bunları haftalarca araştırmış olabilirsiniz. Ama Türk vatandaşları için farklı bir yasal yol var. Ve bu yolu bilen danışman sayısı son derece az. Here is what almost nobody tells you. And honestly, most Dutch immigration consultants don't mention it either. Turkish nationals have a different legal path, one that doesn't run through the standard RVO point system. I work with a lot of Turkish entrepreneurs who are planning this move. Most of them come to me after they have already spent weeks on the wrong process. So let me explain what that process is and what it isn't for Turkish nationals. What the standard route requires. To understand why this matters, let me explain what the standard path looks like for non-EU entrepreneurs, because this is what most people, including most Turkish entrepreneurs, assume applies to them. The main route for most non-EU entrepreneurs is either the startup visa or the self-employed permit. Both go through the RVO, the Netherlands Enterprise Agency. The RVO uses a points-based scoring system to evaluate whether your business qualifies. Innovation, knowledge intensity, Dutch market impact, personal experience, you need to score 95 points. That 95-point threshold is why the rejection rate is so high. The RVO scoring is specific and subjective. A business plan that seems strong on the surface can still fail to reach the threshold if it doesn't address the exact criteria in the way the RVO looks for. For most non-EU entrepreneurs, Emirati, Saudi, Azerbaijani, Kazakh, this is the system they go through. It applies to them fully. It doesn't apply to Turkish nationals in the same way. The EU-Turkey Association Agreement, commonly called the Ankara Agreement or Ankara Treaty, is a trade and association agreement between Turkey and the European Community that was signed in 1963. It's been built on and extended since then. One of its provisions is a standstill clause. Specifically, member states of the EU cannot introduce new restrictions on the freedom of establishment for Turkish nationals that are more restrictive than what was in place when the protocol entered into force. For the Netherlands, that date is 1973. The 95-point RVO scoring system, the one that determines whether your business qualifies under the startup visa or self-employed permit, was introduced after 1973. It didn't exist when the Netherlands ratified the relevant protocol. Under the standstill clause, that system cannot be applied to Turkish nationals in the same way it is applied to other non-EU entrepreneurs. This has been affirmed by the European Court of Justice and applied in Dutch courts in a series of cases. It's not a gray area or a legal theory, it's established case law. What this means, Turkish nationals applying for self-employment in the Netherlands have a different path, one that doesn't go through the 95-point scoring system that other non-EU entrepreneurs face. So what does the Ankara Treaty route actually look like for a Turkish entrepreneur? You're not going through the facilitator and RVO scoring path that a startup visa requires. You're applying directly to the IND for a residence permit as a self-employed person, invoking your rights under the Ankara Agreement. The requirements are different from the standard self-employed permit. You need to demonstrate genuine establishment of a business in the Netherlands. Actual business activity, viable operations. The IND still evaluates your application, but against criteria that reflect what was legally applicable to Turkish nationals before the RVO's current scoring system existed. The timeline can be similar to other permit applications. The documentation requirements are specific. You need to know what the treaty actually asks you to demonstrate, not assume it's the same as the standard self-employed permit. And that part matters. Here is what I see consistently with Turkish clients. The consultants who know this path exists are a minority. If you speak to a Netherlands immigration consultant who hasn't specifically worked with Turkish clients on Ankara Treaty applications, they will probably walk you through the startup visa or self-employed permit process by default. Not because they are trying to give you a harder path. They genuinely don't know the alternative exists. So the first filter when you're evaluating consultants as a Turkish entrepreneur is not which is cheapest or which has the best looking website. It is, do they know the Ankara Treaty route and have they actually applied it? What a treaty doesn't do. Let me be direct about what the treaty doesn't do because this matters. The Ankara Agreement doesn't guarantee you a permit. It changes the framework under which you are evaluated, not the outcome. Your business still needs to be genuine. You still need to demonstrate real establishment, real activity, real intent to operate in the Netherlands. It doesn't make the process instant or unconditional. There is an application, still IND review, still documentation that needs to be right. And it doesn't apply automatically. You have to invoke your rights under the treaty correctly as part of your application. If you apply through the standard non-EU entrepreneur path without raising your Ankara Treaty rights, the IND will process your application as if you were any other non-EU national. The treaty doesn't help you if you don't use it. There are also complicating factors in some situations. If you have previously held certain statuses in other EU countries, if your business has specific structures that can affect how the treaty applies in your case. This is a situation where someone who knows the specific case law and how it's been applied in Dutch courts needs to look at your circumstances. The point is, the treaty changes the path significantly for the right Turkish entrepreneur. It doesn't make the path unconditional. If you're Turkish and you have been planning a move to the Netherlands, here is what this means for you. First, stop assuming the standard startup visa or self-employed permit process is yours. It may not be. Get specific advice from someone who works with Turkish clients under the Ankara Agreement before you plan around the standard route. Second, if you have already spoken to consultants about the startup visa, ask them specifically whether they know about and work with the Ankara Treaty route. If they don't know the route, they are not the right consultant for a Turkish application. Third, understanding the 3D changes how you plan, your timeline, your documentation, your choice of consultant. That's what knowing before you do anything else. The EU-Turkey Agreement, or in other words, the EU-Turkey Ankara Agreement, gives Turkish nationals a different legal path to self-employment in the Netherlands. The Standstill clause means the 95-point RVO scoring system, the one that determines most non-EU entrepreneur applications cannot be applied to Turkish nationals in the same way. This is established under European and Dutch case law, and most consultants and most Turkish entrepreneurs researching the Netherlands don't know it. If you want to understand the broader landscape of Netherlands visa routes, not just the Turkish path, but all 5 rounds and how to determine which applies to your situation, that video is already on the channel. I will link it in the description. Subscribe if you want more content like this.